hold to my lady. There should be on your desk a copy of the archived Code of Guidance that was in force from the 12th of April 2019. So it's the one that was in force when this decision was made. The next iteration didn't come into force until sometime in 2020. Could I just ask, so my learned friend says this application gave rise to an obligation to make a Section 184 decision, and the local authorities' approach to this, finding that there was no local connection, asked a Stage 2 question rather than dealing with or answered a Stage 2 question rather than dealing with a Stage 1 question. In my submission, it must be clearly obvious that a local authority is going to have to make a decision when they receive a new application as to whether or not that has any new facts. Because otherwise, how can they make the decision as to whether or not to accept the new application? And all at paragraph 18.11 on page 142 of that part of the code does is make that clear. The second sentence, starting on the second line down, says where a person whose application has been previously considered and determined under Part 7 makes a fresh application, the housing authority will need to decide whether there are any new facts which render it different from the earlier application. If no new facts are revealed or any new facts are of a trivial nature, the housing authority would not be required to consider the new application and can instead rely on its previous decision.
Can you tell me the reference again, please?
So this is from the Code of Guidance.
Yes. The paragraph number?
I apologise, 1811.
1811, thank you.
So it's on the bottom of page 142.
Further applications.
In terms of where we put that in the bundle, in my submission you have extracts from various iterations of the code behind tab 7, and I would just propose to put it at the end of that tab.
But the only question for the local authority at Stage 1 is, are there any new facts?
That's right.
So let us suppose that we're not dealing with a fresh application at all.
No.
You have an application, it's the first application, comes out of the blue, and the local authority receives the application. So Section 184 is triggered.
Yes.
Right? But the local authority fairly rapidly comes to the conclusion that this is a case where the applicant has a connection with another local authority.
My lord, yes.
So the authority to whom the applicant has applied refers the case to another local authority under Section 198A1.
My lord, yes.
All that tells you, surely, is which local authority is going to carry out the Section 184 inquiries. Doesn't tell you any more than that, does it?
My lord, no.
Right. So because you made some play of 198A1 and saying that you didn't need to go through the 184, but somebody does.
Absolutely, they do. Yeah. Yes. But of course, Mr. Minott could not rely on his residence in Cambridge to give rise to a local connection with Sandwell.
No.
If we then turn to the core bundle...
Could I just ask you a question arising out of 1811? It's just a convenient hook for a point that would come up anyway. You read us up to the words previous decision.
Yes.
But the next sentence says, however, where the fresh application does reveal a change in relevant facts,
Yes.
the housing authority must treat the fresh application the same way as it would in any other application.
Yes.
Why is that not contrary to the 5-year guidance, insofar as it requires you to consider whether any new facts are relevant, which must mean capable of having an impact on the decision?
It's applying fire in my submission. It isn't inconsistent. The Code of Guidance is usually insofar as there are decided decisions, appellate court decisions, that have an impact on the process that is required in relation to Part 7, the Code of Guidance will attempt to reflect those decisions, often in...
No, I'm sure that's what it's intended
language.
to do. I see that. I'm just asking whether you got it right.
Whether the code is right?
Yes. Does it accurately reflect fire?
In my submission, it does, yes. So you will recall from Begum that the comparison that has to be made between the new application and the old application isn't one that is made between the date on which the old application was first made, but it's the date on which the old application was determined. So the comparison that is made is between the last decision that relates to the relevant matters on the old application and the new application. So in this case, you've had handed up to you the review decision of the 25th of September 2019. And that deals from paragraph 2, from number 2, it's not all the paragraphs are numbered, under the heading residency, with whether or not Mr. Minott had a local connection with Cambridge City Council on the basis of residence, and found that he did not.
Say handed up to us.
By my learned friend, I think he gave you copies of
The 25th of September 2019.
25th of September 2019.
Yeah.
So that is the last relevant decision made on on Mr. Minott's first homelessness application. His second application, which my learned friend didn't take you to, is on page 156 in the core bundle.
So just before we go there, just staying with the review decision,
My lord, yes.
the residency, as you rightly say, is dealt with under the heading on the second page, paragraphs 2 to 6.
That's right.
And the reason given for rejecting the local connection
Yep.
is that Mr. Minott has not been resident in Cambridge for 6 out of the last 12 months or 3 out of the last 5
Yes.
years. They don't say, well, you have been resident, but that's still not a local connection.
It doesn't say
So
that.
he,
no.
he fails at the first hurdle
Yes.
because he hasn't satisfied the
He
local...
doesn't even get through the gateway, as you put it, my
Yep,
lord.
because he hasn't
yeah.
satisfied the working definition
Yes.
agreed by the various local
Yes.
authorities.
That's right.
The second application that then says, well, he has now got through the gateway.
Yes. Well, I'm going to come to the second application in just a
Yeah.
moment. I wanted to deal, if I may, with quality of residence, which was an issue raised by my learned Lord Underhill. And it's my submission that it might be regarded as having 4 elements rather than just one, precariousness or security, as one spectrum. So period, the time for which somebody is occupied somewhere, in my submission, would also go to determining whether or not somewhere is their normal residence.
Oh, I see. Well, I don't mind how you do it, but that I would normally call duration.
Yeah, duration. Absolutely. I'm happy.
And the language of the case law, when it refers to these things, treats duration as separate from quality.
I accept it. I accept quality and duration as separate, but they are 4 factors
Oh, I see.
that go into determining whether or not somewhere could be regarded as somebody's normal residence.
Okay.
I'll explain by an example and then come back to the other 2 factors. So, if I bought a house in Cambridge with the intention of living there, and I moved in, but on day 2 it was destroyed, the fact that I have a strong security of tenure, that I'm a freehold owner of a house, and I'm intending to live there for the purposes of performing my role as a lecturer in law at Cambridge University, in my submission means that it is arguable that that's my normal residence from the first day on which I occupy it. And indeed, that proposition appears in the authorities, that somewhere could be somebody's normal residence from day 1, but it depends upon their security of tenure and their intention.
Well, this is akin to acquiring an habitual residence abroad, isn't it? I mean, it could do. Day 1 could mean that day
Yes.
1 residence, you also have a local connection.
Absolutely.
If people went on, but I don't know that answers the point, does it? Really?
Well, if we, sorry, the other two factors on which I was going to suggest are part of normal residence are the nature of the accommodation that's occupied. So if we take the usual example of Diogenes' barrel, you might say you can occupy that indefinitely, but because it is it moves and it doesn't look like a residence to us normally, that doesn't amount to a residence. And that deals really with the point about sleeping in doorways.
Why? You're only looking for a connection with a district, not a particular spot within a district.
You are only looking
if somebody sleeps for 2 years in various parks dotted all over Cambridge, you know, sometimes on Midsummer Common and sometimes on the Backs and sometimes somewhere else, why are they not normally resident in Cambridge? Because
that doesn't amount to residence in my submission. It can't be regarded as a place where I reside if it has no physical attributes of providing security and comfort from the weather and that sort of thing.
Well, I find it hard to see why that's relevant, but you could easily get around that by saying you do live in a barrel, but you move it around.
You could, but all I'm trying to establish is that there's a spectrum of these things which all have to be weighed in the balance in deciding whether or not somewhere is somebody's normal residence.
What's the label for this? Sorry, I dropped the point, but didn't get the label you attached to this second element.
Nature of the accommodation.
Nature of the accommodation.
Thank you very much, my lord. And then the last one, I think, perhaps it sort of really ties in with security of tenure. It's the extent of your right to be there.
Sorry, I thought you said 4 elements.
I did.
Duration, nature of the accommodation,
Yep.
extent of the right to be there. That's 3.
That's the same as precarious and security, which I think was your first one.
Yeah, I accept that. So, yeah.
So the person who sleeps in the park,
My lord, yes.
and does so for donkey's years, and he goes to different parks within Cambridge,
Yes.
you say he doesn't reside anywhere?
I'm saying that it would be within it would not be Wednesbury unreasonable for a local authority to find that nowhere was his normal residence. But that doesn't mean that he wouldn't have a local connection under one of the other heads, or indeed that he would have no local connection with any other authority.
So are you majoring on the word normal or on the word residence?
Or on the phrase taken together?
It says normally reside. It doesn't say normal residence, does it? And don't the authorities draw the distinction between reside and dwelling?
The authorities do draw a distinction between what is the verb residing and the verb dwelling. And that's absolutely right.
Well, it
but,
could be
but they
that
also
the
say
dwelling
that,
dwelling could also be a noun.
and so can a residence can also be a noun.
Yes, but that's not what the
No,
statute uses. It says resides, not
Yes, no,
his residence is in.
I accept that. Now, in the case of R and N, the discussions about dwelling and residence in my submission weren't really necessary for determination of the case.
But they were considering whether a particular statutory procedure applied to a particular place.
That's right.
That is a
hostel.
a building in which, or a room in which somebody was living.
Yeah.
The inquiry required under this Act is not of, I'll use the word attachment loosely, to a particular spot. It's attachment to a district.
So
that's the whole of Cambridge, City.
So if we look at section 199 on page 55 behind tab 6 in the authorities bundle, So a person has a local connection with the district of a local housing authority if he has a connection with it, A, because he is, or in the past was, normally resident in that, for the word there, we can put in that district.
In that district.
Absolutely. But that doesn't mean that any occupation or any staying within that district is enough to amount to normal residence, because otherwise that would simply mean there would be no need for the words normally resident.
Well,
The normal residents must add something.
Move away from my example of sleeping in parks, if you like. I have a whole series of licenses to occupy rooms.
Yes.
For successive periods of 2 months in each case, no security of tenure.
Yes.
And I've been doing that for the last year.
And so
in Cambridge.
And moving from one to the next.
Moving from one to the next. I've
Yeah.
never had any security of tenure in any of them.
Yes.
Why am I not normally resident in Cambridge? I may not be normally resident in any of the particular rooms in which I've stayed, but why am I not normally resident in Cambridge?
Well, in my submission, in those circumstances, then the last lot of accommodation that you have been in might amount to your normal residence. And in those circumstances, you are normally resident in Cambridge, but just not for the period of 6 months. So if we come to the second application, starting on page 156. G.T. Stewart, those instructing my learned friend and representing Mr. Minott, the appellant, have some criticism on the first page, at page 156, of the section of the review decision letter. They say at paragraph 1, the review decision upheld the decision made on the 19th of August to refer our client to Sandwell, but there was no legal power to do so. Section 189, subsection 1 of the Housing Act permits the local authority to make a referral, but it can only do so if a duty under section 1932 is accepted. This has not occurred in our client's case. That is simply wrong, and we know that that's wrong because I took you to the relevant provisions that said that a local authority can make a local connection referral before it's made a section 184 decision.
How does the fact of it being wrong, how is that relevant to the issue before us? Assume you're right that it's wrong.
Well, because it indicates, when we come on to the representations that are made in relation to the new application, you'll see that what is taken is rather a binary approach to the local connection provisions.
Well, they're saying, well, you got the review decision all wrong, but that doesn't matter because we are now making a fresh application.
Absolutely. So what does he say? Let's go straight to that then. What does he say about his new application? Nevertheless, our client has instructed us not to pursue an appeal in the county court. This is because a material change in his circumstances has occurred. This change is that he has resided in Cambridge area for more than 6 months. Whilst our client's position is that he has been in Cambridge much sooner than the council's claim that he has resided in Cambridge since 26th of March 2019, it is clear that on the council's version our client has more than 6 months resident in Cambridge. There can therefore be no doubt that our client now has a local connection in Cambridge. We therefore ask the council to open a new homelessness application for our client. They then go on to say, in addition, our client remains homeless as he has been served with a notice to quit for his accommodation at 27 Gilbert Close, Cambridge, CV43HR. So therefore, presumably accepting that the notice to quit was valid, because otherwise Mr. Minott would not be homeless or threatened with homelessness, a position that's in contradiction to the position that's taken in the possession claim. He therefore meets the criteria for the acceptance of the full housing duty. So the way in which the new application is put is, as a result of the continued residence, he now has a local connection.
Yeah.
So my learned friend says, well, the new fact is the continued residence. And then when he was pressed, he was asked whether or not, is it enough to have just resided there for another 6 months if that wasn't the 6 months that got you over the hurdle of the local authority local authority agreement 6 month rule? And he said, no, that wouldn't be enough. In all circumstances, you'd have to look at the other circumstances.
But his complaint is that instead of Cambridge saying, yes, we accept that you have now been resident in Cambridge for more than 6 months, but you haven't established a local connection, and you have established a local connection, They simply refuse to entertain the application. That's
Well,
his point.
What they say is, we don't accept that your occupation of that accommodation after we had ceased to have a duty to provide it to you and after you had the right to occupy it, we having terminated your licence, was normal residence, and therefore didn't give rise to a local connection. And in my submission, that is exactly the way in which this application is put. And it has to be put like that because of my learned friend's concessions in discussions with you, my lord, my lady, earlier this morning, where he accepted that other than getting over the 6-month hurdle, continued residence would not of itself be sufficient. So it's only because it's a continued residence before and after the 6-month hurdle that it becomes a new fact.
But it's in response to paragraph 5 of the first decision, against which the comparison has to be made.
Well,
So the decision on the 25th of September 2019 was, I am not satisfied that you have been resident in the district of Cambridge for 6 out of the last 12 months.
my lady, that may be how, in my submission, this GT Stewart representing Mr. Minott are solicitors who hold themselves out as knowing about housing law, and they would know that the elements
put
from
their client's case too high, that's all.
Pardon?
They put their client's case too high, that's all.
Yes, but they were saying that the new fact is the local connection.
Yes, but they do also say that the local connection is born out of the 6 months residence. Now,
Yeah.
that could be overstating it, as has been conceded by Mr. Van Heegen. But what they do in the new application is say he has now been resident, even on the local authority's case, for 6 months. And that directly, therefore, takes issue with the previous basis of the decision, or one of the previous bases of the decision, which was, I'm not satisfied you have been resident.
So it may very well be, my lady, that this and my lord, Lord Lewison, that this letter overstates their client's case and is a response to the review decision.
No. Go back one step. The decision of Cambridge City Council. Are you saying that we've got to read that other than by its,
No, I accept that at paragraph 5 that says, given the above, I'm not satisfied that you've been resident in the district of Cambridge for 6 out of the last 12 months.
And then if you go to page 157 in the core bundle, they say, we're not pursuing an appeal.
Yes.
This is because a material change in his circumstances has occurred. This change is that he has resided in Cambridge for more than 6 months. So that's the change. When they go on to say there can be no doubt that our client now has a local connection, that, they say, is the consequence of the change.
Yes.
They may not be right about that.
No.
But the change that they rely on is that Mr. Minott has now resided in Cambridge for more than 6 months, which was not the case at the date of the review decision.
Right.
Why is that not a new fact?
That is not a new fact because the passage of time of itself cannot amount to a new fact.
Well, that's nonsense. Perhaps may or may not be nonsense put that way. Can I put it differently? Can I put it less aggressively?
You said this morning, my lord.
No, can I just put it less aggressively? It is not the passage of time as such. It is the fact that he has been here for more than 6 months, which is referred to in the code as a working definition of normal residence. Now that is the fact they're relying on. They're not relying, to use if you're making this distinction, which I agree I made this morning, on the mere passage of time.
So the position is, as a result of something that is not in the statute, but is a working agreement between the local authorities, the passage from 5 months, 30 days to 6 months, 1 day in one case amounts to a new fact, but where that period of time has already been exceeded, a longer period of passage of time without more, because they're not asserting anything else. They're not saying his daughter now is at nursery, he's got a job in the area.
No,
All they're relying on is this period from 5 months,
exactly.
5.5 months to 6 months.
Exactly.
That's a new fact.
Yes, exactly.
Yeah.
I'm asking you why it isn't a new fact.
The reason it isn't a new fact is because the local authorities agreement is not part of the statutory provisions.
But the original decision depended upon the code in order for, I think it's Mr. Penn. No, sorry.
No, it's not. It's a man called
Minott.
Perdios.
To say, paragraph 4,
Yes.
clear that you started to reside in Cambridge on 26 March 2019, when the council provided you with interim accommodation. You've not accrued 6 months residency in this area. And that would be correct, because it was the 25th of September 2019. Given the above, I am not satisfied that you've been resident in the District of Cambridge for 6 out of the last 12 months or 3 out of the last 5 years. So this letter on the 25th of September 2019 is predicated upon the basis of the code. And when the new application is submitted on the 17th of October 2019, it could be that the local authority are hoisted by their own petard, because they make the point, well, we now have been here for more than 6 months, because the original decision didn't say, we are not satisfied that however long you've lived here, you do not have a local connection.
No, but with respect, my lady, the 6 months period is used as part of the local authorities agreement, and in this case, the case was referred to Sandwell Metropolitan Council, who accepted the referral. I'll come back to that in a moment. As my Lord Lewison has pointed out, that the 6 months residence isn't sufficient of itself to give rise to a local connection.
I know that. I know, but what I'm saying is that,
so
no, I'm obviously being very
no, you're not
clumsy in explaining this. If the letter of the 25th of September 2019 points out explicitly that the local authority are not satisfied of residency for 6 out of the last 12 months, it's almost throwing down a gauntlet, so that when somebody does cross the 6 months, which also happens to be specified in the code, that they make a new application and they say, well, Luke, before you said I hadn't been resident for 6 months, now I have. That's a fresh fact. Please now look at my application. You may reject it,
yeah,
but please look at it afresh.
Well, my lady, if it is the position that where the residence is one that takes you from 5 months, and I think it was 30 days, because the 25th of September is 1 day before before the 6 month expires. If it's a period of residence that takes you from that 5 months and 30 days to the 6 months, it amounts to a new fact, then it seems to me that local authorities are going to be faced with a large number of new applications in circumstances in which they have already decided under section 198A1 to refer the case to another local authority.
Well, if they are, they are.
The first application was turned down on the ground that the gate was shut.
Yes.
The second application says, well, now the gate's open.
Yes.
Have another think.
Yes.
So why is that different from a child turning 16, for instance? Or why is that different from somebody who has 2 children aged 9 of different sexes occupying the same bedroom, and one of them turns 10? So it's now overcrowded.
My lord, it is different because in relation to the person who's turning 16 to 17, that's provided for in the statute and not in the local authorities agreement.
So your only point then is that this 6 month working definition is non-statutory.
Yes.
and therefore satisfying the non-statutory definition, which you couldn't
It's
do
not-
before, cannot be a new fact.
No, I didn't say it cannot be a new fact. It's for a matter for the local authority to consider whether or not it is a new fact. And of course, the relevant issue in relation to whether or not it's a new fact is whether or not it would be sufficient to give rise to a local connection.
Wouldn't you be on safer ground if the letter of the 25th of September 2019 had said, we bear in mind that you're 1 day away from the 6 months which the Housing Code suggests that we should have regard to. But we take into account the fact that you've been here for almost 6 months, but you have not, by that, established a local connection. But that's not what the letter says on the 25th of September.
No, but in my submission, this isn't about, the review decision in relation to the previous application doesn't set the legal parameters of the second application. They're set by the authorities and the statute.
But the comparison, as you rightly said, is between what the local authority decided first time round
Absolutely.
and what the application said second time round.
In relation to whether or not there are any new facts.
Yeah.
It may very well be that the review decision letter of the 25th of September 2019 could have been better expressed, but this is a case in which the local authority has performed the relief duty. So it has been meeting its obligations under the Act to secure emergency accommodation for Mr. Minott on his application. In the course of that, it has decided, because it can make this decision now under the Homelessness Reduction Act before it's made a substantive decision as to what duty is owed him, that he doesn't have a local connection with Cambridge, but does have a local connection with Sandwell and has referred him to Sandwell. Sandwell has accepted the referral. Now, Sandwell could have said, no, we think he has a local connection with you, but they don't.
So are you saying that because Sandwell accepted the local connection referral, that there is no new fact that Mr. Minott could rely upon to make his new application to the local authority?
What I'm suggesting is that it is a infinitesimally precise requirement that should not be encouraged, to say that there is a difference between a period of residence that gets you over 6 months and whether or not that satisfies a local connection. I'm saying that in response to this second application, the local authority was entitled to say it isn't a new fact because it's not going to give you a local
Are you
connection.
saying that the code is misguided in adopting a working definition so that everyone knows where they are?
No.
Then why shouldn't it at least be relevant that that helpful working definition is satisfied when it wasn't before?
Well, the working definition is no more than a working definition and mustn't be slavishly applied in my submission,
Yes,
because we know from Betts that local connection means more than simply...
No, we're not talking about local connection. We're talking about the gateway.
Well, if you take me to the relevant provision of the Code of Guidance that you consider expresses that once somebody's got over the gateway, that amounts to a new fact, I'll respond.
I'm not sure I've understood the question.
So you say that the Code of Guidance says that the local authorities agreement is a working definition.
Oh, yes, of normal
Provides a
residence.
decent working definition of what is local connection, but it's not.
No, I think it's a working definition of normal residence,
It is.
isn't it?
Yeah.
That's what the code says, to which the local authority is statutorily required to have regard. It's
It is
paragraph
statutory.
10.7.
Absolutely. It's statutorily required to have regard to it, but that doesn't mean that it must slavishly apply it, and that's clear from the authorities. Excuse me. The case on the application of the Code of Guidance was excuse me, Mark. So it's a decision of Lord Justice Chadwick, I apologise. Osbeck and Ipswich. So that's divider 16, page 185. So a paragraph 37. You'll see there's about halfway down the paragraph a sentence that starts with the word thirdly. Thirdly, the one purpose, indeed perhaps the principal purpose of the referral guidelines and their predecessor, the agreement on procedures, and that's the local authorities agreement, is to facilitate agreement between authorities on the question whether the conditions for referral are met, or to provide a basis for speedy and inexpensive resolution of disputes between authorities on that question. Fourthly, that the purpose is unlikely to be achieved unless authorities do follow the guidance which those guidelines provide by applying that guidance generally to all applications which come before them, and this is the important one. And fifthly, that an authority is not to be criticised for following that guidance in the individual case, provided they have not closed their mind to the possibility that the particular facts of that case may require a departure from the guidance when they would apply more generally.
But how does that sit with the fact that one day before the 6 months is up, the local authority is saying you haven't done 6 months,
Well,
so you haven't passed the through the gate? I mean, you know, you're having your cake and eating it there, I think, Mr. Grundy.
with respect, my lady, it isn't. The 6 months is not sufficient to establish local connection.
No, we all agree that.
We agree that. What Mr. Minott is entitled to say in relation to the application for review, your review fails because you haven't got 6 months.
Right. So he then comes back after 6 months and says,
I now have 6 months.
I now have 6 months. That's
Yes.
my new fact.
Yes.
And you seem to accept that that is a new fact.
No, I don't accept that's a new fact. Because what he goes on to say is, I have 6 months and ipso facto, that means I have a local connection.
No, the ipso facto, with respect, is the conclusion from the new fact. It's not the new fact itself, as indeed page 157 makes clear. Your earlier point was it's not a new fact because the 6 month is only an agreed working definition between local authorities. It's not a statutory criterion.
Sorry.
Now that's a different point, good, bad or indifferent, but it's not the same point.
My lord, I apologise. I was responding to my lady's point, and I'm not saying that I accept in this case that from the 5th month 30th day to the 6th month 1st day, occupation amounts to a new fact. But I am saying that in the review decision, the local authority was entitled to rely on the local authority's agreement to say you haven't been here for 6 months yet. The decision that there was no local connection in my submission is in effect a decision that the continued period of occupation doesn't amount to a new fact. So between an original application being determined and a new application, there is bound to be a period of time. If my learned friend is right, that period of time in every case gives rise to a new fact.
No, it just obviously isn't the case.
No, it doesn't give rise
No,
to a new fact.
if he is right, a period of time that involves the passage from less than 6 months to 6 months is a new fact. That's all he's saying. That's all he needs to say, and it's all he says.
So my submission in that respect is if the local authority is satisfied that the residence is normal residence and they make that decision, then the period from 5 months and 30 days to 6 months doesn't amount to a new fact because it isn't going to get you over the hurdle.
What do you mean it isn't going to get you over the hurdle?
Well, it isn't going to get you from the before 6 months normal residence to the after 6 months normal residence. So it's not enough. My learned friend says, and I will have to come to this in due course, that normal residence equals residence. I don't accept that, and I'll make submissions why that's not right. But if the local authority is satisfied that the period from 5 months and 30 days to 6 months and 1 day, those 2 days, was not as normal residence, then it's not a new fact.
Why not? It's not a matter of what they think.
Well, with respect, it is, because it's the authorities are that it's for the decision.
Well, it's only Mr. Justice Singh who says that. I'm not convinced that's right, but in any event, that's not really the point here. The point here is whether passing 6 months is a new fact. That can't depend on a legal analysis of its effect, because that would get you into the territory which FIRE says is not for, doesn't arise at this stage.
If what is being asserted, my lord, is that those additional 2 days were sufficient to give rise to a local connection.
No, it's not. That's not what's being asserted.
No. But if it was, the issue then would be, were those 2 days of normal residence? So the fact that is being asserted is whether or not those 2 days are 2 days of normal residence.
Well, the first decision, the review decision, didn't consider the question of normal residence at all. It just said you're not resident.
Yeah.
Didn't say yes you were, but it's not normal or anything.
Yes. No, it didn't.
Of that kind.
My lord, no.
So the new fact asserted on page 257 is we now have residence. Now, it might have been open to Cambridge to say that's not normal residence.
No.
But that's not what Cambridge did say. Cambridge said the reason why your submission does not provide new information is because you don't have a local connection. That's the reason that they gave for not even considering the application.
Yes.
They didn't say, we accept you now being resident for 6 months, but it's not normal residence. They just said, we're not even going to consider it.
Well, if we go to that decision at page 149, my lord, I think that's a simplification of what they do say.
Yeah. An applicant can't make a further application based on exactly the same facts, unless there's a change of circumstances, facts which are neither trivial or fanciful. There's a certain tension between those, because if there is a change of fact, it's not exactly the same, but never mind. Your submission does not provide new information. The reason for this is because Mr. Minott does not have a local connection to Cambridge.
Yes.
So that's going to the end of the process.
Well, it goes on. In your submission, you state that Mr. Minott has resided in temporary accommodation since the 26th of March 2019. Mr. Minott has resided in this accommodation for large periods of time without permission from the City Council under a homeless application. Firstly, when he refused to leave following the Section 198 referral to Sandwell, and secondly, when he wasn't provided with accommodation pending review, and lastly, following the Section 202 decision, of which he has still not left. He then goes on to deal with the proposition in Mohammed. And then it says at both dates he does not have a local connection and has not gained 6 months within the borough in temporary accommodation pending inquiries. So in my submission it does deal with the asserted fact of the additional accommodation, but goes further and says, and that's not going to get you a local connection.
What does it mean he has not gained 6 months within the borough? What does that mean?
Of normal residence. So the accommodation that he was provided, so it says, it goes on, within the borough in temporary accommodation pending inquiries. So in the point about Mohammed is that the accommodation was occupied by Mr. Mohammed throughout, pursuant to a duty that was owed to him. In this case, Mr. Minott has occupied the accommodation after his licence to occupy it was terminated, and after the referral was made to Sandwell Metropolitan Borough Council, And so after the duty to him, which you've seen, my learned friend has taken you to this, after the duty of Cambridge to house him ceased. So what this is saying is this is a case that is out with Mohammed and Hammersmith and Fulham London Borough Council.
We've been looking at obviously what is a crucial issue in the case about whether or not a new fact was asserted in the second application, and we looked at that pretty thoroughly. Is there anything more you want to say on that aspect?
My lord, my submission, to repeat my submission is, when you look at the decision that was made and is contained in the email dated the 21st of October 2017, you have to do that by reference to the new fact that is asserted in the application. So my learned friend didn't want to take you, I don't understand why, to the application. But in my submission, when you look at the application, what is being asserted is the 6 months occupation give rise to local connection.
Yes. But what the covering email says on page 150 says, please find attached correspondence concerning my client's case, and I'm assuming that's the letter of the 17th, it's the same date.
Yes.
Please can you confirm that a new homelessness application will be investigated? So at this stage, they're not asking about the outcome, they're asking for an investigation. That's all they're asking.
But in my submission, that seems to me to be, it's not clear whether or not they're saying you're accepting a new application or whether or not you're going to reject it under the Fahir process.
Well, what Mr. Patel or Ms. Patel is saying is, please investigate and determine this application because there has been a material change of circumstance. And then when you look at what that is,
yes,
it's explained on page 157. He's been residing in Cambridge for more than 6 months.
My lord, yes. Which gives rise to a local connection.
Well, that's the consequence which they assert.
Well, this is all.
That's in my submission.
This is a point we've now been over two or three times.
Absolutely. In my submission, mate, it's a distinction that is, if it is right that mere residence is going to be a change in fact, ignoring for the moment the 6 month rule, and I'll come back to the 6 month rule in a moment. If it's right that continued occupation is going to amount to a new fact in every case, then there's nothing to stop people making renewed applications and the Fahir.
You're attacking Aunt Sally because that's not the case.
No. So the only difference in this case is we have the difference between the 5 months and 30 days occupation.
Right, and that's what we've been looking at for the last half hour, and I think we have your submission on it.
Right. Well, in my submission, I won't repeat my submission. So, residence, normal residence. Whilst in Re-N, or RN, sorry, it is suggested that, it's stated that residence is less secure, or has a lesser degree of settled accommodation than dwelling. Their lordships also say that the construction of the normal words residence and dwelling in any case depend, of course, on the statutory provisions in which they appear. And so in my submission to read across from N and Lewisham London Borough Council to the Housing Act 1996 is dangerous and unhelpful, as indeed it was to suggest that in some way the Rent Act 1977, 68 and the Housing Acts 88 and 85, the use of the word residence in those has any relevance. In my submission, in this case, normal residence is used for the purposes of establishing a local connection. So in Betts, which is behind divider 10 in the bundle. Page 113, my lord, my lady. The House of Lords considered the local connection rules as they appeared in the 1977 Housing (open brackets) Homeless Persons (close brackets) Act. And if I could ask you to go on to the last page of the speech of Lord Brightman on page 128 of the bundle, 628 of the law report. Lord Brightman said as follows: as regards the meaning of normally resident in the context of section 18(1)(a), this will take its colour from the fact that residence of any sort will be irrelevant unless and until it has been such as to establish a local connection with the area in which such residence subsists or has subsisted. I doubt whether in these circumstances any elaborate attempt at a definition of normally resident will be profitable. They are ordinary English words, and which in many contexts will mean what this House said ordinarily resident mean in Shah, 1983 2 Weekly Law Report 16. But they are only a subsidiary component of the formula which a housing authority will be applying under section 5 of the Act. If the residence of an applicant has been of a sufficient duration to create a local connection, no difficulty is likely to arise in deciding whether the residence was normal. But if it were necessary to decide such a point in a particular case, I do not think that the housing authority would be wrong if they applied to the words normally resident the meaning which in Shah was attached to the words. So the point about normally resident for the purposes of section 199 in the 1996 Act, 1A in the 1996 Act, is that they have to be construed in the context of creating a local connection. And in those circumstances, in my submission, normally resident cannot mean simply residence, because they have to be coloured by the interpretation or the purpose of the section which is establishing a local connection.
So is the code misguided in
Well, the code
saying that normal residence is residence?
The problem with that, of course, is that it uses the word residence to interpret the word, or the word reside, I apologise, to interpret the word residence, which perhaps isn't very helpful. It's sort of a circular.
So is it misguided? Are you saying that the...
Well, no, because if you take the word reside in the same way as the word residence, then in my submission there's something more required than simply being there.
Well, Lord Brightman tells us between D and E that he doesn't think the housing authority would be wrong if they applied the meaning which in Shah was attached to ordinarily resident. And if we turn back to page 625, between D and E, we can find the meaning that Lord Scarman in Shah attached. Yep. So he says, unless it can be shown the statutory framework or legal context requires a different meaning, ordinarily resident refers to a man's abode in a particular place or country which he has adopted voluntarily and for settled purposes as part of the regular order of his life for the time being, whether of short or long duration.
My lord, yes. And in my submission, a part of that is your right to be there.
Well, that's not what Lord Scarman says.
Well, if your occupation is precarious, I don't see how your occupation can be for settled purposes. If you are staying there by barricading the door and saying I'm not going to give the local authority possession back again, even though they have a right to possession, in my submission that clearly is not for settled purposes. My lord, my lady, my learned friend criticised His Honour Judge Lickley, QC, for deciding the wrong question. My learned friend scales an argument before His Honour Judge Lickley is at divider 8 in the core bundle at page 63. Paragraph 1, what my learned friend says is, the main legal issue in this case is whether occupation of homelessness, temporary accommodation after the expiry of a notice to quit is normal residence and can therefore count towards a local connection. There is a subsidiary factual issue as to whether the occupation was unlawful in this case. This has been dealt with in the witness statements. He went on, paragraph 32. Page 69, my lord, my lady. The claimants, under the heading the claimant submissions, above paragraph 31, paragraph 32, the letter of application dated 17th of October 2019 revealed new facts. It stated that the claimant had acquired a local connection by normal residence of 6 months in the preceding 12 months. Paragraph 34. The new fact was not trivial. It gave the claimant a residence and therefore a local connection with the defendant's area. And then paragraph 66 on page 75, my lord. As was pointed out in Muhammad, the purpose of the Act is to favour those who have established a local connection with an area. The Act does not appear at all concerned with the date of the expiry of any notice to quit served in relation to accommodation occupied. The way in which it is put throughout is that the continued residence, the new fact was residence to acquire a local connection. And in my submission, the distinction between the primary fact of residence and the local connection is one that really has, I accept that the local connection is a function of the normal residence, but that is clearly what was being asserted on behalf of Mr. Minott in his new application letter and in the judicial review. And in my submission, that is the issue that His Honour Judge Lickley determined, and he determined the case on the basis upon which it was put by my learned friend.
But the way it was put made it clear, didn't it, at page 70, paragraph 36, that the application was not based on the passage of time. It was based on what had happened during that time. During that time, the claimant had acquired 6 months residence.
Yes. So my learned friend says in his submissions that the judge uses the phrase unlawfully resident, and that the respondents have used the phrase unlawfully resident and that there's no distinction, or there's no definition of unlawful residence that appears in housing law. His Honour Judge Lickley doesn't use the phrase unlawfully resident once in his judgment. And the local authority hasn't used the phrase unlawfully resident.
Well, the judge does say the claimant had been in occupation unlawfully.
Yeah, he doesn't use the phrase unlawfully resident. In occupation unlawfully, in my submission, is saying it can't be your normal residence in these circumstances if you're in occupation unlawfully. It's also suggested by my learned friend that the judge...
But the real question is that right? is he right to say you can't have normal residence if you are in unlawful occupation?
In my submission, whether that is right or not is not an issue that arises in this appeal, because the local authority, it was for the local authority to decide whether or not the Mr. Minott's unlawful occupation of the premises could amount to normal residence, and they decided that in this case it did not.
Where did they say that?
In the
Who did coin the phrase unlawful residence? Because in the submissions that the judge records at paragraph 38 onwards, he does use that word, unlawful occupation.
I think the phrase unlawful residence has been coined by my learned friend. In terms of where does the local authority say your unlawful occupation, excuse me, can't amount to normal residence. If you look at the response to the letter before action, at page 152, paragraph 3.
Paragraph 4, did you say?
No, paragraph 3.
3.
Sorry, page 100. Which page are you on? Page 153.
Page 152.
Yes.
So it would help if I took you, I think, to the letter before claim, which is at page 2 of the supplemental bundle.
Yes.
So that sets out at pages 2 and 3 a series of facts. Page 4 and 5 it sets out section 198 of the Act, and at pages 5 and 6 it sets out extracts from the Code. At page 7 it goes on.
Page 7.
At page 7, it was page 6, sorry. Page 7 of 63, but page 6 of the letter, I apologise.
Yep.
I have a number of different paginations on the page.
Where are you reading from?
I'm not reading from anywhere yet.
Where are you about to read from?
Yeah, paragraph 4. Moreover, the council is not entitled to discount residents on the basis that they have withheld permission due to making a referral because a referral was never lawfully made. Section 1981 states that a referral can only be made if the council accepted a duty under Section 1932 of the Housing Act 1996. As I said previously, that's simply wrong. This has not occurred in this case. In addition, a referral can only be made once the conditions have been accepted by both authorities. We know that Sandwell Metropolitan Borough Council did accept the referral in this case. So
why is that relevant to anything we have to decide?
Well, because in my submission it indicates that the Sandwell Metropolitan, that the duty that was owed to Mr. Minott had ended.
Yeah, I don't think there's any issue about that. There may have been in the letter for action, but things moved on.
I thought you were taking us to this
I am.
documentation to support your proposition that it can't be normal residence if you are in occupation unlawfully.
Yes.
That's what you said.
That's what I said.
And you said that that's what Cambridge said. And I asked you, where did they say that? And you've now referred us to the letter of claim, which is not a Cambridge document.
No, it's not, because I wanted to take you then to the response.
Yeah.
Okay. Paragraph 3 of the response at page 152 in the core bundle, my lord.
Mm-hmm.
The point is incorrect. Mr. Minott does not have a tenancy but had a licence to occupy because it is accommodation pending decision under Section 188. Applicants accommodated under the interim duty are not considered to be occupying premises as dwelling and therefore exempt from Protection of Eviction Act. A court order is not needed to evict a tenant, however it is good practice to do so. We do not have the reserve.
Yeah, where does it say that this is not normal residence? Because it's unlawful.
Mr. Minott, it has been made very clear at each point that Mr. Minott does not have permission to reside in the accommodation, which is why a notice to quit was issued. at the point of the referral to Sandwell Metropolitan Borough Council.
Well, all that's true as a matter of fact, but why
Yes.
does his continued occupation unlawfully, why is that incapable of being normal residence?
So, in my submission, it's to be inferred from what the local authority are saying is that they have made a decision that his continued occupation after his right of occupation has been terminated is not capable of amounting to normal residence.
What would you say to a squatter who's been in occupation of a house for 5 or 6 years? That can't be normal residence because it's unlawful?
No.
Why not?
Because it would...
Why don't you say that? If your proposition is it can't be normal residence...
No, sorry. Right. So I'm not saying that general... The Aunt Sally that was set up to be knocked down is that the decision is that unlawful residence can never be normal residence.
I'm not sure it's really an Aunt Sally, because I think that's what the judge said, isn't it?
Well, I don't think he does.
I know he said unlawful occupation, but
No, but also-
subject to that point,
He's saying
which I'm
in
not
this...
sure was a real distinction. He
Right, he's
says
saying...
the unlawful occupation of the accommodation cannot amount to a new fact.
Yes, in this case.
What makes this case different from a squatter case?
Well, in this case, the local authority has actually terminated. So they had given somebody a licence and they've ended it. In the squatter case, until and unless the freeholder, the true owner, comes and brings the possession claim, the squatter is asserting their right to be there.
They don't have a right, they're just trespassers.
Well, that's not right, is it?
They didn't even have a licence. In this case, at least Mr. Minott had a licence from the local authority to start with.
Well,
in the squatter case, they just, I suppose, break in and sit
well,
in
that's
the
not
house.
right, is it? As the person in occupation, they have the right of the person in occupation who is effectively acquiring the adverse possession right.
Yeah.
Only if they've been there a long time.
Well, no, but that...
Are you making the separate point, this is my Lord's territory rather than mine, that as against someone else, they may have a better right, someone else trying to displace them,
Yes.
not the true owner?
Yes.
That may be true, but is irrelevant.
Yes.
Why is that relevant?
The reason
That
it's...
would be true also of Mr. Minott against a burglar.
Well, the reason it's relevant in this case is because Mr. Minott, in this case, was granted permission to occupy pursuant to an obligation, and that right was determined. And he continued in occupation, notwithstanding that his right of occupation has been ended. Whereas with the squatter's right of occupation, or the squatter's occupation continues until a possession claim is brought by the true owner.
So somebody without any right ever to occupy may be in a better position than somebody who did once have a right, but it's expired.
Yes, they may be in a better position.
And that is when we're considering what is normal residence.
Absolutely.
It seems like a rather odd proposition, I may say.
Oops. Well, in my submission, it isn't, because if there is a squatter who is in occupation of accommodation for a long period of time, you can see that they will, until and unless somebody starts to bring a possession claim against them, they are safe there. In this case, the local authority had referred Mr. Minott to another local authority who had accepted the referral. The duty had ended and the local authority had served a notice to quit. Now, I would not press the proposition that any unlawful occupation of accommodation could never amount to normal residence. And I don't think the judge found that. If and insofar as he did, I don't support his finding. What I say is, in this case, Cambridge City Council was entitled to find that Mr. Minott's unlawful occupation did not amount to normal residence.
Is really what you're saying, that the essence of the matter isn't unlawfulness, the essence of the matter is precariousness, and in the circumstances of this case, for the reasons you've given, the unlawful residence was precarious, whereas in the case of a squatter who'd been there a long time and had no particular reason ever to believe that the landlord would try and get him out, it's not precarious. Is that the real point?
Well, that's part of the point. I mean, in this case, the Cambridge City Council has issued possession, served its notice to quit and issued possession proceedings. They hadn't issued them by the time of the second application. But the other aspect of this is in the squatter case, the squatter is not owed a duty by a local authority to house them. In this case, as my learned friend has shown you, when Sandwell Metropolitan Borough Council accepted the referral, the duty for him to be housed passed to Sandwell Metropolitan Borough Council. And indeed, Sandwell Metropolitan Borough Council had made accommodation available, and he was simply to go to Sandwell Metropolitan Council and they would house him. So in my submission, it's those, if you take those two things together, he was provided with this accommodation pursuant to a duty. The duty has ended and we have terminated his right to occupy, but there is a right that another local authority has.
But you surely can't acquire normal residence elsewhere by means of an offer which you haven't accepted.
No, I'm not suggesting he had normal. I'm not suggesting that that was necessary. Sorry, Cambridge didn't have to decide that he had normal residence with Sandwell because that was historic and they'd already established that.
Yeah.
So that's an irrelevance with respect, my lord.
Well, that's why I wondered why the offer of accommodation from Sandwell had anything to do
Well,
with it.
the reason it has something to do with it is because it's not a case of not being housed. It's a case of being housed by the authority to which the application is being properly, pursuant to the provisions of the Act, referred.
So if Mr. Minott had given up possession of the address and gone and sofa surfed for 6 weeks,
Yes,
he would be resident.
he would be I'm whether or not he would be normally resident
Well, why not?
would be a matter of fact.
In Cambridge, not
In Cambridge.
not,
Yeah, if he's sofa
not
surfing,
on a particular
you know,
sofa,
sorry.
but in Cambridge.
I understood that to be the case. I understood that to be the premise of my lady's question, was that the sofa surfing was happening in Cambridge.
Yes, so
Yeah.
there's no question of unlawfulness, which the judge refers to in
No.
his
So
judgment. It becomes, all right, I've given you back your house. I'm
Yes.
doing so under protest. I think you're wrong. I will now go and I will make my own arrangements for 6 weeks and then I will make my fresh application.
my lady, the unlawfulness of the occupation isn't the only basis upon which accommodation might not
Well,
be.
okay, answer the question first and then we'll go backwards if you like. So that would have been sufficient
No,
to open the
Not-
gateway. Why not?
not necessarily.
Not necessarily, but
No.
in normal, sorry,
Yeah.
in usual circumstances, if Mr. Minott had come forward and said, I now have over 6 months residence in Cambridge, that would have been a new fact. Do you agree to that which had led to the review, the letter 25th of September referring?
I don't agree.
Why not?
I don't accept that without more, that would have amounted to a new fact.
Well, it is a new fact, isn't it? Namely, he's
Well,
reached 6 months.
It's the passage of time.
Well, I suppose it's the point we had before. So
Yes. So if Lord Justice Hill gave a judgment. Apologise. In
Begum.
So that's divider 15 in the bundle of authorities, my lord, my lady. Paragraph 91. So if I perhaps read you from paragraph 90, my lord, my lady. The expression used by Mr. Justice Wolfe in Delahaye and Oswestry Borough Council, cited with approval by Lord Brown Wilkinson, was that a would-be applicant cannot rely solely upon the same matters as he relied on in support of his earlier application. That approach requires some inquiry by the local authority into what matters are now relied on, with a view to deciding whether they are the same matters or whether they are new matters. Moreover, concluding in for here at 1402 that it is impossible to say that there has been no relevant change in circumstance. Lord Brown-Wilkinson appears to have been keeping alive the concept of a change of circumstance applied in other cases. Paragraph 91. Because time has passed, the facts will never be precisely the same. To remove any and all entitlement to investigate the contents of an application form would encourage bogus claims to the detriment of applicants generally. I would maintain some entitlement to inquire into the contents of the form with a view to deciding whether or not relevant new matter can realistically be asserted to be present. The extent of that entitlement will depend on the facts of a particular case. And so, the mere passage of time isn't sufficient. In this case, what is said is the passage of time is sufficient because it gets me over a provision that appears in a local authority agreement that is relied on by local authorities to apportion responsibility for homeless applicants as between themselves.
I still don't see how that answers the question I pose, which is, if your point is that unlawful occupation cannot count towards a normal residence, why a lawful occupation of a sofa or other premises couldn't then amount to 6 months over the line, as it were, and a new fact?
Of course, it could amount to a new fact.
Right.
But it's also right that it might not amount to a new fact. As my learned friend says, it depends upon the facts of the residence in question. So when you have the passage of time, you have to look at what else has been happening.
Just before we leave, we leave the judgment of Lord Justice Pill, as I read it, he wasn't entirely comfortable with how Lord Justice Neuberger had put it. One sees that from the end of paragraph 89.
Yes.
And I think there is at least a nuance of difference between what he says in paragraphs 90 and 91, compared with how Lord Justice Neuberger had put it.
Yes.
To the extent that that is the case, he's in the minority, isn't he? Because Lord Justice Keane agreed with Lord Justice Neuberger.
He is. I accept that. But what he indicates is that a subsequent application is always going to have had a passage of time.
Well,
So,
that's obvious.
insofar as there is a passage of time, it isn't on precisely the same facts.
Yes, but as you say, you just said, when you have the passage of time, you have to consider what has happened in the
Yes,
intervening period.
absolutely. Yeah. I agree. I accept that. And it actually comes down to quite a small point in effect, is the passage of time that gets you from 5 months and 30 days to one that gets you 6 months and 1 day a new fact that, because of the local authorities agreement, means that you have an argument.
I think that the passage of time which gets you from 15 to 16 is a new fact. I think you said that. So you now get into a priority need.
Yes.
And I think you accepted that 2 children of opposite sexes sharing a bedroom, one turning 10, can be a new fact if it results in statutory overcrowding.
Yes.
So when we're looking at what has happened in the intervening period, it's not necessarily something, so to speak, external that's happened.
Absolutely.
It can be a consequence of the passage of time.
Absolutely.
Yeah.
I accept that.
Right. Now, we have been considering, I think, the issue of unlawful residence, and I think I understood what your position is on that. Do you want to say anything more about that?
My lord, no.
Where do we go now?
Well, really, those are my responses to the appeal.
Right.
Unless I can be of any further assistance.
Well, can I just ask you one point? I kind of slightly misspoke earlier, or said something that came out wrong about Mr. Justice Singh's decision. I said that's only a judgment of Mr. Justice Singh. What I meant was it's only a judgment at first instance.
I understand.
In every other respect, that's great weight. But I do wonder whether it is in fact entirely right. Not sure whether this will come up or not, but if I can have your submission in case it does.
Yes.
The issue in question C, Bagram, is whether an application is the same as a previous application. In other words, whether it raises new facts with a very minor shading about trivial or fanciful. Now, is that really a matter which is to be analysed as a question of judgment for the local authority and so challengeable only on grounds of reasonableness? Isn't it actually a binary question to which there's only one right answer, and therefore if it comes before a court, it is for a court to say, well, this obviously was a new fact or this wasn't. There's no real room for, well, it might be a new fact, but it might not be a new fact, and it's for the local authority to decide. After all, there's no statutory power. It doesn't say if it appears to the local authority to be a new fact. Yeah. There's a whole area of this is
outside the statutory provisions.
Yes.
Yeah.
And so with great respect to Mr. Justice, saying if that's really what he said, we needn't bother to look at it unless you want to take us to it. I wonder whether actually it isn't always binary.
Well, in my submission, because the route of challenge is a judicial review, the challenge must be on a judicial review basis, therefore encompassing those grounds upon which a judicial review can be brought, and the court should not be imposing its decision as to whether or not there is a new fact, unless, of course, that is a decision that no reasonable authority properly directing itself could have come to.
Well, there are lots of cases where on judicial review a challenge is based on the fact that a council made a decision which was not open to it.
Yes.
As a matter of law.
Yes. And
that's not just because I think really what I'm putting to you is the nature of the decision taken here is one to which Wednesbury isn't really the right approach. It's either right as a matter of law or wrong as a matter of law.
In my submission, my lord, that would be a very awkward place for the court to go in relation to these decisions.
Well, it depends on on why the decision was made.
Yes.
It may be one thing to say there's no new fact, maybe another to say there is a new fact, but it's trivial, where there may well be a question of judgment involved.
My lord, yes.
Well, that rather itself depends on what the test of triviality is.
Yeah. So, my lord, if the decision that there was no new fact is such that the court is of the view that there was a new fact and nobody could have come to the decision that there was no new fact, then if that's in my submission is encompassed within.
You'd say that is perverse. Well, it's obviously judicial review. Yes, I'm just wondering whether there is ever an area of judgment for the local authority, given the kind of decision it has to make.
Yes.
Well, I have your submission on that.
Thank
you. It may not arise.
My Lords, my Lady, I want to come back briefly on 3 points. I want to look at section 184, then have a quick look at paragraph 18.11 of the code again, and then go back to bets and normal residence. So, firstly, section 184, I'm just concerned that maybe my Lords, my Lady didn't see subsection 4. So I just want to draw your attention to subsection 4, which is on page 21 of the authorities bundle. So this was inserted with the...
Sorry, which page of the authorities bundle?
21.
Yep.
So this was inserted along with the other Homelessness Reduction Act 2017 amendments.
Or
So,
some of the words in it were.
yeah. So it now specifically covers section 198A1 referrals. So although the power to refer comes from section 198A1, the duty to inform the applicant of that referral is here in 184 subsection 4. So, in my submission, what should have happened here is they should have made a decision under 188, 184, subsection 4, if their decision was to refer the new application. Point 1. Point 2.
And that then means that your client could have had a review of the decision.
Yes. Because then, as we looked with my lady, I looked at section 202, and one of the things you can review on 202 is the decision to refer.
And that's provided by subsection 5, because the applicant must be informed of the right to request a review.
Exactly.
Yeah.
Yeah, otherwise it's not a valid 184 decision. And the relevant bit of 202 we saw was 202(1)(d), any decision whether the conditions are met for the referral. So you would decide the conditions for referral were met, and then you'd inform them under 1844. So that's the first point. Second point, there's a short point dealing with paragraph 1811 of the code that my learned friend handed up at the start of his submissions. We don't agree that that paragraph reflects the law. There's obviously a subtle change in the wording between or of a trivial nature to, however, where the fresh application does not reveal a change in relevant facts. There's a difference there between wording between relevant and trivial. And relevant and trivial, well, we've had this discussion before. They may or may not.
We have, but I think at that point, you were suggesting that relevance was apt as long as relevance didn't mean the same as material.
Yeah,
but then we got into rather a verbal quagmire.
Yeah.
Yeah.
So the last point then is re-bets. My learned friend relies on the interpretation in re-bets for what he says about normal residence necessitating some kind of settled purpose. And I think it's important to bear in mind that re-bets is based on Shah, and Shah is then reconsidered in Mohammed and in N, a decision of the House of Lords and then the Supreme Court. And in my submission, that requirement for some kind of settled intention goes. If one looks at Mohammed, the starting point is top of page 156. So it's really the end of paragraph 17. We looked at paragraph 18, but we didn't really look at paragraph 17.
Can you give me the page reference again, please?
Yeah, top of 156 of the authority.
Thank you.
So there's reference there at the top of the page to Shah and the quote about adopted voluntarily and for settled purposes. And then at 18, and we did look at this, it's clear that words like ordinary residence and normal residence may take their precise meaning from the context of the legislation in which they appear. It seems to me that the prima facie meaning of normal residence is a place where at the relevant time the person in fact resides. Therefore, questions to be asked are not appropriate to consider whether in general or abstract sense such a place would be considered an ordinary normal residence. So in fact, when they come to look at residence and normal residence for the purposes of the 96 Act, they move away from the Shah definition. And this, in my submission, they jettison the idea of settled purpose because the examples they give.
Sorry, can we just put this into context? It's the local authority's appeal. Right? Think?
Sorry, we're talking about Mohammed and...
Mohammed.
Yes.
It's the local authority's appeal.
Yeah.
It's Mr. Arden for the local authority who's propounding the Shah test.
Yes.
And Mr. Luber for the applicant is saying normally residence refers to residence in a district, not the nature or quality of the accommodation in the district. So those are the competing arguments.
Yes.
Lord Slynn quotes Shah, paragraph 17. And since the local authority lose the appeal, I think one can infer that he doesn't accept that Shah is the governing definition.
Exactly.
Because that was Mr. Arden's submission.
Exactly.
That's not accepted.
Yes. So although it was accepted in Betts, it's not accepted in Mohammed when looking at the 96 Act, and he rewrites the definition that they do accept. So just above C, he's rejecting this idea that it should be an ordinary or normal residence. And then he sets out the definition that I've referred to before. So long as that place where he eats and sleeps is voluntarily accepted by him, the reason why he's there rather than somewhere else doesn't prevent that place from being his normal residence, i.e. we're jettisoning settled. And then he gives examples which back that up. He may not like it, he may prefer some other place, but that place is for the relevant time, the place where he normally resides. And then he talks about if he takes his few belongings and moves into a barn for a period of work on a farm. And it says that is where, during the period, he normally resides, however much he might prefer some permanent or better accommodation.
Yeah.
And that's then followed in N on page 303 of the authorities bundle. And it's paragraph 44 at 303. Again, we looked at this before, but effectively what the Supreme Court do there is approve the Mohammed definition of normal residence and approve the jettisoning of the Shah criteria. So quotes in paragraph 18 of Mohammed that words like ordinary residence and normal residence take their precise meaning from the context of legislation in which they appear, and then sets out the test that voluntarily accepts in which he eats and sleeps the relevant time where he normally resides. And then the jettisoning of settled is further reinforced by the fact that they then go on to draw a distinction between dwelling and residence. So dwelling is the one which is the one that has more of a kind of settled intention. Residence is just where you eat and sleep. And that makes sense because if you define what is normal residence by reference to what gives rise to a local connection, it's all very circular. What's the point of residence? Because if the normal residence is something that gives rise to a local connection, then normal residence doesn't really add anything to, it doesn't become a gateway to local connection anymore.
Well, I think we also have to realise that this statute is dealing with people who are homeless. So most of them won't have residences.
Yes, exactly. Yeah.
That's why they're there in the first place.
Exactly. My lord, my lady, those are my submissions in reply, unless I can be further assistance.
Thank you very much.
Thank you.
We will be reserving our decision in the usual way. Copies of our judgments will be circulated in draft so that the parties can agree consequential matters, or if they can't, can provide us with brief written submissions on the basis of which we will determine those consequential matters prior to formal hand down, and also, of course, to correct any typographical or other minor factual errors. Thank you very much.